This video examines the procedure for and the implications of amending a patent during patent litigation. Section 105 of the Patents Act states that if a patent is the subject of a court proceeding, the court may, on application by the patentee, direct that a patent be amended. If the patent is the subject of litigation, or a current court proceeding, the court has the power, on the application of the patentee, to order the amendment of the patent in a manner that the court specifies. It must be noted that the court has complete discretion with respect to making orders for a patent amendment, as long as it is not contained within the list of unallowable amendments that are contained within Section 102 of the Act. So, if you were a patentee, what would be the procedure for amending your patent if it was the subject of a court proceeding? Well, the first step for an applicant who wants to make an order under Section 105 of the Act is providing the Commissioner with a notice of intention to apply for the order, as well as an accompanying advertisement. The advertisement must identify the proceeding or proposed proceeding in which the application will be made, the particulars of the amendment sought, and the applicant's address for service. The advertisement must also state that a person intending to oppose the application who isn't a party to the proceedings must, within 28 days of the publication of the advertisement, give written notice of their intention to oppose. This must be given to both the Commissioner and each party to the proceeding. The Commissioner is then required to publish the advertisement in the official journal. The applicant then may file an application within 50 days after the publication of the advertisement. Then, once filed, the applicant must serve a copy of the application together with a copy of the patent showing the amendment sought on the Commissioner, each party to the proceeding, and each person who has given a notice of their intention to oppose the application. If a court makes an order directing an amendment, the patentee is required to file a copy of the order within 14 days. Once a copy of the order is filed, the patent is taken to have been amended in the manner specified by the court. So this brings us to consider the implications of amending a patent during litigation. One of the biggest implications of amending a patent during a patent litigation is the ability to allow the patentee to validate what would have otherwise been an invalid or partially invalid patent. To put it into other words, by allowing an amendment to a patent, the court is allowing the patent to be protected, where if it weren't for this section, the patent would be otherwise unprotected. In order to fully consider the procedure and implications of amending a patent during litigation, it's best to look at cases where this has happened. Let's examine the case of Bristol Myers Squibb Co. and Otsuka Pharmaceutical Co. against Apotex. To give some context, Otsuka was a patentee over certain methods of making a drug used to treat schizophrenia. Bristol Myers was the exclusive licensee of the patent. The patentee and licensee, Otsuka and Bristol Myers, brought an action against Apotex for patent infringement. Apotex denied any infringement of the patent and cross-claimed for the revocation of the patent on the grounds that it was invalid. As the patent was already a subject of a court proceeding, Otsuka, the patentee, made an application to the court under Section 105 of the Patents Act that they be allowed to amend their patent. Upon Otsuka making this application, the court examined the proposed amendments in light of Section 102 of the Act. This was to determine whether the requested amendments were allowable. The court then exercised its discretion under Section 105 of the Act in determining whether the proposed amendments be allowed. It was held that all of the proposed amendments, except two, were allowable under Section 102 of the Act, and that the allowable amendments should be allowed as a matter of the court's discretion. The court then granted leave to be heard in relation to the remaining amendments that were not allowable under Section 102. I hope that this has been an informative video. If you have any questions, please do not hesitate to comment them below.